Thank you, Mr. Chairman. I'm adding, Mr. Chairman, for emphasis, and my colleagues will come with other questions. Mr. Chairman and members of the court, the first question my colleague raised, and I agree with him entirely, was in respect to the uncertainty of the offense, whereby when you do and do not do, you commit an offense. So if we are crossing the road, essentially we have an officer saying don't cross, so that when you cross, you are disobeying an order. And you have one on the other side saying cross, yet when you cross, you disobey again. The point I'm making, Mr. Chair, is that the necessity for a law to be clear, not only to members of the distinguished UPDF, but everyone, is just so that they know when they are conducting their affairs, when they are out of the law or within the law. And for emphasis, Mr. Chairman, again in the case of retired Captain Ambiguity and others versus the Attorney General, concerning petition 44 of 2015, the court addressed itself. I will just refer to a short quotation, but I can emphasize. Citing an American case, Kulema versus Lawson, the court was of the view that, as generally stated, the void for vagueness doctrine requires that a penal statute defines the criminal offense with sufficient definiteness that an ordinary person can understand what conduct is prohibited and not prohibited, and in a manner that does not encourage arbitrary or discriminatory enforcement. The rationale, Mr. Chairman and members of the panel, is that I should know whether to cross the road or not to cross the road is an offense. That was an example. But also, it is intended for an ordinary man. Mr. Chairman, in society we have individuals who are higher there. We have individuals who are in the middle, who we ordinarily refer to as reasonable. They are not far off. And then we have the others who are lower, who in different aspects are referred to as the riffraff of society. The requirement for a law to be certain lowers itself to the lowest in society. The law should be very clear that an ordinary person, the lowest in society, is very sure about how they are going to conduct themselves. And that was the submission that that offense, which says to do anything or not to do anything that constitutes or compromises the security of the defense forces, means that I am effectively at a cross junction. I don't know whether to go left, right, north, south, east, or west. The other one, the third question my colleague raised was in regard to the court being impartial. Mr. Chairman, the courts have recognized that military courts, like the one we are in, is intended to charge or to try officers for disciplinary matters. And of course, in our UPDF Act, there is a clause which brings in the civilians. But again, Mr. Chairman, the courts have made a pronouncement about the character of the military court, it being appointed by the executive, and therefore the officers forming the courts being subject to the executive. And the courts have made it clear in the case of the Second Lieutenant Ambrose Ogwan versus Uganda. It says that courts which have to try any civil or criminal matter must be independent. It's the command under Article 28(1), and the courts have said by virtue of the appointment of the military court is not independent. Mr. Chairman, we are not making or referring to the individuals because who are before us, or before whom we are standing, because we know that theirs is an appointment and they are executing the lawful mandate of their appointing authority. So it's not character of individuals, it is the institution, Mr. Chairman. Because I've said military courts are not independent and that they are military courts of the executive, they belong to the executive. Moreover, the charges they try are brought by the army. And Mr. Chairman, the court made reference to two sets of people. Those who are not subject to military law, I suppose like me, and those who are subject to military law. I reckon, Mr. Chairman, like yourself, Mr. Chairman, and the officers before us, because they are soldiers serving, doing a national duty of protecting our country. But he said that persons who are subject to military law, like every other person in this country, enjoy fundamental rights which may only be limited in the manner allowed by the Constitution. He said that judges of independent courts cannot be under the administrative control of the authority that brings the charges. In this case, my Lord, Mr. Chairman, rather, to the extent that the court is of the institution of the UPDF, and the offense that has come, one of which is to compromise the security of the UPDF. Again, it shows that the institution which placed all these gallant officers in their offices, with the executive, is complaining before them. Put simply, because, Mr. Chairman, I'm a parent, I have a grown-up child, and I am offended by my neighbor, Mr. Kalibala, and I constitute a panel of my children to try the matter where Mr. Kalibala is accused. And I am the complainant. The likelihood that my children will find against me when I buy their clothes, the uniform, when I pay their salaries, is unlikely. But more importantly, in the eyes of Mr. Kalibala, is not likely to see that as a fair process. Because after all, the person charging him is one who I can direct to attend to me by instruction. And they must attend to me whether they want it or not. Because as officers, you answer to the high office. Mr. Chairman, in that respect, the courts have taken note of individuals who are subject to this law and said that officers and militants of the Uganda People's Defense Forces do not, by joining the UPDF, surrender their rights and freedoms on account of joining the UPDF. We are thankful that today we have name tags. So if I turn around, I can see Mr. Walimbwa. He doesn't surrender his rights because he has joined national service in terms of the UPDF. He enjoys the same rights as I enjoy. So if in one dispensation I am entitled to a fair and biased court, we are the same, all of us reading the same image, and therefore he is entitled to the rights and enjoy. So the courts have said that such rights and freedoms are available to the officers and the militants of the UPDF because they are available to all the other Ugandans who live in this country because they are inherent. The other point, Mr. Chair, My colleague referred to Article 137